The trademark registration process is really very straightforward. If you are using your trademark already in commerce, you're in good shape. But if you aren't, there's a thing called an intent to use trademark application, which you can file, which goes through the whole process. But at the very last minute, you can show the trademark office your statement of use of the trademark in commerce and get your trademark that way. But in normal situations, you're using your trademark in commerce and you have some statement of use. Usually it's a web page or a promotional flyer, or maybe even a product that's already labeled with your name and your logo. Of course, we prefer to trademark the logo and the name separately because sometimes you're only going to want to use your logo for your marketing purposes. As your logo gets better and better known, it becomes a shortcut. Think of often how many times you see a mere logo of a company and how valuable that can be. So you want to apply for a trademark usually on both of them together. And the statement of use can be as simple as a web page where you're actually using it, but it has to show that your company is the source of that product or service and a little bit about the product or service that you offer. In your statement of use, your trademark should use the little TM symbols that you often see on trademarks. Use TM before the registration process occurs, and then you can use the circle R after you actually have a trademark registration from the trademark office. Trademarks are allowed based on the type of industry you're in. So it's possible you can have the exact same trademark in two different industries owned by two different companies. If you think of Pandora Music and Pandora Jewelry, or many years ago Apple Records was the Beatles record label before Apple Computer got into the music industry. So you want to have the industry you have, and you want to have your trademark and your logo ready when you talk to a patent attorney, if you go through a patent attorney when you do this process. Once you have that information available, you apply with the trademark office for your trademark, and the trademark examiner will do several things. The first thing they'll do is they'll take a look at your trademark and make sure it isn't generic, car for car, or merely descriptive, red car for red car. Make sure you actually have a trademark. And a proper trademark will be something that describes your product, like an adjective describes a noun. Think of Kleenex tissue or Apple records. They don't describe record or tissue. They describe something about that record or tissue that's unique, and that's what makes it a trademark. The second thing the trademark examiner will do is make sure that your trademark is not deceptive. It's not similar to anyone else's trademark. If either of those situations arise, the trademark office will issue a rejection, in which case you'll probably have to get an attorney to help you through it if you haven't already, to get around the objection. Often there's several things that can be done, depending on where the process is and the nature of the objection. But if the trademark examiner finds nothing wrong with your trademark, they publish the trademark for opposition. When that happens, the public is told, hey, this trademark is going to be issued. If you think it interferes with your business or will harm you in some way, you may file a statement opposing the registration of the trademark, in which case you'll have to go through your attorney and argue or negotiate with that person who's in opposition to your trademark. But if no opposition is filed, your trademark will go on to register. Once it registers, you no longer need to use the TM logo. You can use the circle R logo, which shows that your trademark is registered.